So let's. I know that both of us have a lot of insight into this question. I got this. Yesterday. So I just thought I'd just throw it out there. I'll start with a couple of ideas, and I think you just come in there with some of the brilliant, funny things that you've seen, because it's something that's happening more and more often. So long story short, it's around the question of spoliation. I think you and I always include this in our talks when it comes to evictions and things like that. It shouldn't actually be there, but I think it's just such a common thing, something that people can't grasp or understand, that it's always coming up. And I mean, every week we get a question around spoliation. We've explained it a million times. And I don't want to go into the detail on the explanation, except to say, if you basically stop someone from possessing the property or disturb their possession of the property in any way, if you're a landlord and you do this to a tenant, it's more than likely an act of spoliation if you don't have a court order. Simple as that, right? Court order, crucial. With court order, anything goes as long as the court order says so. But without a court order, you're not allowed to, right? So what I was asked yesterday is, what are the common things that landlords often do to tenants that can get them into trouble? And this was kind of the funny thing is, interestingly enough, because it came from the perspective of how far can I go without getting into trouble, right? So that's naturally like our typical clients would be asking, what are the boundaries? How far can I push them? And obviously the answer to this is, if you're asking that question, you probably should not be doing something, because just by asking that, you've probably already crossed some kind of boundary. But it's just interesting. So like experiences I've had, most common, aside from actual outright intimidation, physical assault or physical intimidation, right? Which, I mean, obviously it's going to get you into trouble. I'm not going to state the obvious. But situations, for example, where, and obviously also outside from the locking a door, changing the locks and not allowing somebody in, because those are obvious ones that we've spoken about before and said you can't not let the person into the house. I mean, that's just a blatant no, right? You shouldn't disconnect electricity. That's a biggie as well. Also, don't destroy the house or like take it completely apart. That's a biggie, because then there is no house and you've obviously dispossessed the person. But interesting ones is can somebody move in with the person there? And like my short answer to that example is, if it's a commune where multiple people are living in the commune, then yes, people can move in with these tenants. But if it's a house and it's only this guy's family in the house, then no. The short answer is no. And an example I've had of this is, we had a client that got into the property and outside in the yard set up a security house, right? And the question of spoliation came in, and his argument was, well, they still have possession of the house. And the counter argument by the people living on the house is, well, we also have possession of the yard. And now you've disturbed my possession by putting a security house there. Where I haven't had a challenge, as an example, is access through a security boomed off area, where people didn't stop the access. They just simply implemented a different process, because their argument was, this person's now a visitor. He's no longer actually a lawful occupier, so he needs to complete the information as a visitor would in order to be able to get in. And that actually worked. The court went, well, they got into the house, they managed to get in, no one stopped them. So it just made their life a little bit difficult, but they are technically unlawful if the lease was properly cancelled. So we're not fighting that battle today. So Cilna, I don't know, from your side, what are some of your shares?
I must say that the access through boom gates thing, I've seen that as well, where they say, okay, now you're a visitor and you need to go through the visitor thing. And I think that one is such a tricky one, because depending on the judge or the magistrate you draw for the particular thing, and I've seen so many of these cases where the intention of the parties would typically lead to the answer. And,
sure.
and it depends on the court that you are in when it comes to these things, whether they're going to say, okay, yes, it's spoliation, or you know what, no, you still have access. It's disturbed, so now it raises the question around, can you use the mandament? And I'm of the opinion that you can. If your possession's been disturbed, you can use the mandament functionally to rectify it. So I suppose it's up to who asked the question. I must say, the best one that I've seen was very often, Bruno, with these things, I always think the old saying of, cutting off your nose to spite your face does become very clear and obvious in these situations. So the weirdest one that I've had, this was actually a while back, it must have been about 6 or 7 years ago, and my client got frustrated, didn't want to pay for the eviction, and the reason why he didn't want to do the eviction is, he said it's too expensive. So what he did, and I think the cost of this must have been at least 20 times the cost that the eviction would have been. So this was like the poster child of, you weren't thinking clearly, yeah, my friend. So what he did is he went in and he took the roof off, the roof of the house. And I mean, we all know between foundation and roof, those are the most expensive parts of a house. So to take the roof off to prove a point, I thought an eviction would have been cheaper and actually would have been quicker, because it took obviously time to remove the roof. It's going to take a lot of time to replace the roof.
Yeah.
So between costs and time saving, I didn't think that was the most practical approach to proving a point. And I tell that story sort of laughing about it, but it's really a very serious thing, because the damage that you're causing to your property by doing something like that, interfering with the electricity supply and things like that, just to try and force the tenant into a direction. I always think it's at the best of times a little silly, for the simple reason that there is a practical way. Most of the times it's tenants we're talking about. So you have a landlord that holds a deposit. On cancellation of the lease agreement, obviously the deposit becomes available for anything that's due in terms of the lease agreement, which in most cases would be a rear rental. So you can immediately use the deposit already towards your eviction. It's not that expensive, let's be fair. Yes, it could be a costly thing, but if you can utilize the deposit, you have some money available, as you do anyway as a landlord. I mean, when a geyser bursts or whatever, you need to have cash available. So I always think, to try and avoid the cost of an eviction and then end up spending much more money. I've seen these guys who are contracted to move in with illegal occupants to try and get them out. But all of those things have a cost involved. And the problem
sometimes to get them out,
then you still need to do the eviction. So it's a little bizarre. And I think at the same time, the risk of these things are very real. I've had a client once who, well, obviously it wasn't a client. If it was a client, it wouldn't have been a problem. But a guy that called me about an eviction, and he decided not to do it again because of costs. And he paid these guys to move in. And they actually just ended up stealing all the occupant stuff. And I mean, then the person that allowed access is an accomplice to that crime.
And I've told you that story where the doors were locked and there was heart medication inside.
Yes.
And that's a typical example where somebody actually got hurt because of that conduct. As much as the landlord thought it justified, I gave an example to a client yesterday where I said, the problem is there's always two sides to a story. There's landlords that also do really bad things, where they go to, they want to increase rent today, so they lock the doors because they feel, you know what, now you must pay them more. And that's the problem. As a landlord, you don't think about that. And you can't say, yeah, but I wouldn't do that, but the law doesn't work for me. The problem is, the law's not there to just work for you. The law's there to find that balance. You could be that landlord Who's going to decide? The court. And that's
Yeah.
why you go to the court, so that the court can say, are you that bad landlord or are you that bad tenant? Oh, bad tenant. Okay. Order. Oh, bad landlord. Stop. Yeah. So I suppose that's the difficulty, is like we are very one-sided when it comes to obviously our interest that we're trying to protect.
Exactly. And if I always have a bit of a rule. If you picture yourself into a situation where you tell the story about what you're planning to do as a landlord or as a tenant to your mother or your grandmother, what would they say? Would they say like, well done, you've done a good job? So think about the person that's your typical.
It depends what area you're from and what kind of childhood you had.
Yes.
Like I've seen some grandmothers that would be the first people to climb on that bandwagon.
Exactly. So ask my mum. My mum is like a very big on, what is right and what's wrong is wrong, and whether my kid is on the wrong or the right side. Wrong is wrong and right is right.
Yeah.
So picture my mother, and if she would say you're probably crossing a line, you might be on the wrong side of the law. I don't know if that helps.
Fair enough. Yeah, I suppose. So speak to your conscience. If you have to ask, am I allowed to do it? You're probably not.
Yeah, exactly.
Although just to add an interesting one, in case anyone is interested, with the municipality, especially with the freehold, what I did find is there was a stage where there was an argument where if you don't pay, so basically, long story short, word your lease agreements correctly, because when it comes to disconnection of utilities, the council is allowed to disconnect utilities, but not by you simply going and asking, because that is you disturbing possession. But if council does it automatically by following their own process, it's not. So just kind of be careful how the lease is also worded, because obviously, now there's an obligation on you in terms of the lease to actually pay for the water and lights. So you also need to make sure the lease is actually worded properly, that if you don't pay, you don't end up getting, again, into trouble, and it's a spoliation. But typically speaking, most leases would say that water and electricity is being paid for. If the municipality switches off, you could probably just say, well, it was them that switched off, it wasn't me. I don't know if you agree.
I agree with you. Yesterday, I actually did a webinar for SPOA on utility disconnection, legal utility disconnection. And I think the issue with that case from 2019, Eskom versus Masenda, where the court held that utility disconnection cannot be seen as an act of spoliation if it's a contractual agreement between the parties. I think there was a misinterpretation on that one, where a lot of attorneys came out and said, okay, that means we can contractually agree that the landlord can just unilaterally disconnect, sometimes for non-payment of rent as well. I mean, that's not nearly what the case said, but I think it's crucial to appreciate the fact that exactly what you just said, Bruno, if your contract's drafted correctly, and it is a contractual obligation that the landlord will provide utilities or allow utilities to be provided to the premises, and you're allowed to use it, but the tenant will have to pay the landlord in return. On correct process, the landlord would be entitled to then request that supply gets stopped, but only in as far as it relates to that particular service. And the tenant still, if the landlord doesn't follow the correct process, still would have a claim for at least specific performance, but then he must tender performance. So he must say, I did pay for my utilities, but I think the problem is the moment the court comes out with a case like that, where they clarify that something's not spoliation, it doesn't mean that it's right. And I think that gets into a bit of a gray area for people. But I think you and I are both saying it's so clear. You must follow the word of your contract. You can't go outside of it, and because the tenant doesn't pay, there's no law that allows a landlord to disconnect utility supply for a tenant that's not paying his rent. That's it, the two just doesn't link up in any way, shape, or form. If you buy a property, for instance, on auction and it's taking forever to take transfer, you do have the right to approach a court to obtain an order, a court order that will disconnect the utility supply. Or to Bruno's point in the beginning of the conversation, that would be in a position to, grant an eviction order, and now we can send the sheriff to do the eviction. But we can't, as much as we see people not necessarily sticking to rules, it doesn't mean it's a good idea to not stick to rules. It's important, especially as landlords, but also as tenants, to do the right things, right?